Okay, welcome everyone to our event 10 years on the United Nations Guiding Principles on Business and Human Rights. It is a great pleasure to welcome all of you. Of course, in particular, our three guests, John Ruggie, Anita Ramasastry, and Robert McCorquodale. This is an event brought to you by many institutions, in particular the European Society of International Law, the Interest Group on Human Rights in particular, and by the Institute of International Law of Peace and Armed Conflict at Ruhr University Bochum. And as you have seen from the title already, what we are here today is to celebrate a 10-year anniversary. It's almost exactly the birthday of the United Nations Guiding Principles. And what we have thought to do is not, as we always do in the field of business and human rights, discuss about John Ruggie and his principles, but to discuss with John Ruggie his principles. So that is really the main purpose of today, and that's what we have been looking forward to so much. I have agreed with the panelists the following format. John and I will conduct a little interview. We thought this is a bit more interactive in an online setting. We know it's also very warm in many places in Europe and North America. So we appreciate the time that you're taking, that you could also spend at the pool, but I'm sure this is much more interesting. And then afterwards, Anita and Robert have very kindly agreed to give short statements on the interview and on the guiding principles, of course. I'm almost embarrassed to say that I will very quickly introduce John Ruggie. I know he really doesn't need introduction, but at least for those of you who are not so familiar with the field of business and human rights, I want to say that he is a professor of human rights and international affairs at the Harvard Kennedy School, which in full disclosure is my alma mater as well. So many, many years ago, I don't think he remembers it. I was his student. And he's also a professor, affiliated professor at the law school. He is a fellow at the American Academy of Arts and Sciences, has received various awards that I cannot list, all of them: American Political Science Association, International Studies Association, also from the Berlin Social Science Center. He has been identified as one of the most influential international relations scholars, for instance, in multiple surveys published in foreign policy. And of course, most importantly for us today, he has worked extensively also at the United Nations, first as the UN Assistant Secretary General for Strategic Planning, where he worked very closely with Kofi Annan on subjects like the Global Compact or the Millennium Development Goals. And then in 2005, he was appointed as United Nations Secretary General Special Representative for Business and Human Rights. And in the context, he has developed a famous framework and then also the guiding principles, which the United Nations Human Rights Council endorsed in 2011. Nowadays, he chairs the board of the nonprofit organization Shift that advises governments, companies, and civil society in the field of business and human rights. With that being said, John, 10 years ago, you got a task, and I don't know how happy you were when you received it, but at least it appears to be a difficult task, because in 2005, so 16 years ago, apologies, the situation was a bit different from today. There was no consensus. There was a big divide between the global north and the global south. There was definitely a divide between the advocacy community and the business community. You said once in an interview, every company, it seemed to you, had its own human rights standard, but there was certainly not one human rights standard. So my question is, in this process that you have had with your guiding principles, was there ever a moment where you realized, wow, this could really be very big and this could really become the gold standard, at least for a long time in the field of business and human rights? When did you realize that this would have such an impact?
Did I have a wow moment? Well, the only wow moment that I recall was on June 16, 2011, when the Human Rights Council endorsed the guiding principles unanimously. It was a rocky start, as you pointed out. There was no common language, let alone a common framework or common standards. And the mandate emerged as a result of the sort of collapse of a previous initiative by a subcommission on business and human rights, which essentially attempted to transpose state-based obligations onto companies, multinational corporations. And business hated it, governments didn't like it, and the Human Rights Commission said this has no legal standing, don't anybody do anything with this, etc. And they asked the Secretary General to appoint a special representative, essentially to start the process all over again. But because it was such a contested area, my term was initially limited to 2 years. The standard is 3 years with the possibility of a 3-year extension. Mine was limited to 2. And it was further limited by what I was asked to do, which is basically to conduct research and to clarify concepts, like corporate complicity or corporate sphere of influence and the like. And so for the first 2 years, that's all I did. I generated a bunch of papers, doing research on, where's the problem, which sector is the problem most severe, what region, and so on and so forth. What do we know about how human rights obligations are enforced domestically, and so on and so forth. Just a bunch of research papers. So at the end of 2 years, they said, hey, you've just given us a bunch of research papers. You didn't make any recommendations. So take a third year and make some recommendations. I was okay. Third year, we spent putting together a framework, the Protect, Respect, Remedy framework. In the area of business and human rights, it's the legal duty of states to protect against human rights abuses by any actor, including business. The corporate responsibility to respect is a fundamental social norm, and there's a need for victims of human rights abuses to have greater access to remedy. So we just outlined a framework and gave some examples of what might fit into it. And the council welcomed it and said, now please spend another 3 years and operationalize this framework. And so that's how the guiding principles eventually came about. It was an unusual process, I have to say. But in the end, it seems to have worked.
Talking about this unusual process that you just mentioned, John, I mean, a lot of people say that the process by which you elaborated these principles was really key to their success. And what I mean, of course, is the multi-stakeholder process that you initiated. And of course, you said yourself already that the Human Rights Council in the end endorsed for the first time that they used the language of endorsing, a legal text that was not drafted by governments, right? So we had this unusual process of multi-stakeholder consultation and so on. And then in the end, we have a unanimous endorsement by the Human Rights Council by a text that governments hadn't even, agreed on. That's quite remarkable. So what can we learn from this process of international rulemaking, also for other issues that are contentious in international relations? And what do you say to the critics who say, well, that all sounds nice, multi-stakeholder process and so on, but there is also reasons why governments, who are in most cases elected, make these negotiations?
Well, it was actually a hybrid process. So it was a formal mandate given by a formal intergovernmental body, and then several years of consultations with virtually any stakeholder that's ever been mentioned in relation to business and human rights on all continents except Antarctica. Pulling together these thoughts, and then presenting this to the Human Rights Council. And they endorsed it. So it wasn't something made up, completely outside. It was made up outside of the formal process, but it was begun and ended with a formal process. And I believe, and I have some evidence for the fact that governments could never have negotiated the guiding principles themselves. In fact, when I presented them to the council in 2011, the ambassador of Algeria, on behalf of the group of 77, said, this is the wonderful, wonderful work. We're so appreciative. You've done a great job. And now we should submit these to governments for their consideration and improvement. And the only time I lost my cool speaking to the Human Rights Council, I said, no, don't do this. You'll never end up in as good a place. And they seem to have accepted that. And there is a lesson in this, I think, for other areas. Back in 2014, there was an article in the European Journal of International Law by Howell, Wessel, and Wooders. Don't know if you recall it. The article is called "When Structures Become Shackles." And they argue that what they call a thick stakeholder consensus behind an informal government arrangement can be normatively superior to the, quote, thin state consent that we see so often in relation to treaties. And they explain, and I'm going to read a quote here. They explain this when in the case of a thick stakeholder consensus instance, the actors involved are more diverse and expert. The output is elaborated more carefully and coherently, supported by a broader consensus, both ex ante, when the norm is developed, and ex post, when the norm is accepted because it works. So I think there was an understanding. I don't know whether governments will want to do this again, but there was an understanding that the guiding principles would not have come about through an intergovernmental negotiation.
We've talked a lot about the international level now. Of course, business and human rights is also a very important topic at the national level, right? And it's in the spotlight over and over again. Responsibilities of corporations for human rights, also for environmental degradation, climate change, and so on. Just think about the recent judgment against Shell by a Dutch court, I think a few weeks ago, or in Germany, and I think in Europe. The big topic in the field of business and human rights at the moment is the supply chain law that the German parliament just passed 10 days ago, very recent. So how do you see the role of these national actors, national parliaments, legislators, and courts? Do they work enough with your principles? Could they do you see this as a logical prolongation of the United Nations guiding principles, or should they make more use of it in some way?
Well, I guess the truth is that I've been very pleased and fortunate to have worked with the German government and the European Union for some years now on developing domestic bases for the guiding principles, because that's ultimately where they have to be embedded if they're going to be enforced. There's not going to be an international enforcement mechanism. And so the German, as you say, the German parliament has now agreed to a mandatory human rights due diligence law, and the European Union, the Commission, is at work on one that promises to be a bit more robust than the German, in that it would include civil liability provisions, and also go further. The German law is essentially focused on tier 1 suppliers, whereas the European Commission proposal, at least as we know about it, will focus on the global value chain. But it's absolutely critical, and governments were very slow to get into the act. You know, the first 5 years or so after the guiding principles, governments were essentially saying, oh yeah, business has to respect human rights. Let's see how we can encourage that. And then you began to see the introduction of modern day anti-slavery legislation that sort of drew on the notion of human rights due diligence, and then the French law, and now this current batch of laws. The Dutch case against the case against Shell in Dutch courts was fascinating, and I've never come across a case quite like it, because what it did was to impose emissions limitations on Shell, but the rationale for it was essentially human rights based. They said in Dutch law, we have, Dutch law is largely civil law, the civil code, but there are elements of customary law. And we have a customary law standard, they said, of a duty of care. And to interpret that in a business case, we look to the guiding principles for advice on how to frame this. And so it was actually based on the right to life and intergenerational equity and such things, coming right out of the human rights area. It was a fascinating case. The guiding principles have been mentioned in other court cases, but never as a cause of action. Usually just as sort of as part of a sketch of how norms have shifted at the international level.
Well, let's see whether the Dutch case stands. Now, it was just the first instance, of course.
Right.
I want to go back to one point you mentioned, which is liability. And of course, when I was a bit involved also in the discussion about the German law, and when you speak to employers, to corporations, of course, one thing they are very interested in is, this due diligence, how does that relate to liability? So, and that's in the German case, but also in the European case that you just mentioned, is of course one of the core discussions, where there's also disagreement. Does it mean if I have observed my human rights due diligence that I'm free of liability? Or does it not mean that? Or is there at least an indication that if I can show as a corporation that I have observed human rights due diligence, then in all likelihood, I will be absolved from liability. So how, with all your experience, with all these decades of experience that you have with the different sectors, with the business sector, but also with the advocacy sector, what is your take on the relationship between due diligence on the one hand, human rights due diligence, of course, and liability?
Yeah, I think, companies are justifiably concerned, and advocacy organizations are very pleased that liability is being talked about. But I think both sides exaggerate the significance of the liability provisions that are likely to come out of this. So I think we have to keep in mind, first of all, that liability is a subset of a broader category of accountability. And all of these laws and directives will include a whole series of other accountability measures. There will be administrative measures, there will be fines, access to export credit, any number of ways of holding a company accountable for whatever its role was in human rights abuse. Secondly, the scope of liability is likely to be fairly discreetly differentiated depending upon the particular role that a company played. So in the guiding principles, we have this very simple differentiation between cause, contribute, and linked. If you were to take that as a starting point, you already see that if you caused a case, caused an abuse, the chances are more likely that there would be some liability than if you were merely linked to a case. So the issue of liability is far more subtle and complex than either the corporate lawyers who worry about it believe, or the advocates who think it's going to solve all the problems.
Okay, I'll limit myself to maybe one more question because we want to have enough time also for Robert and Anita and for the questions from the audience. But of course, I have to also ask one a question relating to something that's going on at the moment, and that's a big sports event. You can maybe hear my voice. That's the reason is the Germany game on Saturday, which was quite spectacular and cost me my voice. So we have at the moment the European Championship in football, or as you would say in soccer, going on. But of course,
I say football.
You say football because you have Austrian origins. That's why. But most people would say soccer. Anyway, so I mean, while the European Championships are maybe also a bit have also interesting human rights questions. We could discuss that too. But the bigger concern, of course, lies, for instance, with the upcoming World Cup next year in Qatar, right, where we have seen, of course, serious human rights problems, let's say human rights abuses in the preparation of the World Cup, at least probably also during the World Cup we'll see it. And my question is, so while FIFA, for instance, has incorporated and embraced, I think, the United Nations guiding principles, I think you had even a quite good relationship with Sepp Blatter at the time, no? Or at least he was approaching you to help with that. So they have embraced these frameworks, but we don't see them translated into reality, right? So what in this particular field, business and human rights in the context of big sports events, what can we do to improve the situation here? Because it seems to be a field where the impact has not been there sufficiently yet. Or would you not agree with this assessment?
Well, I think the first thing I would want to say is that I don't think I've come across a situation as complex as the organization of mega sporting events. It is basically a network of private law, and is barely touched upon by public law. So we think of Japan as hosting the Summer's Olympics. Well, yes, Japan is hosting it, but the legal relationship that you can draw on is between the International Olympic Committee, right, which is registered under private law provisions, and the organizing committee in Japan, which is a private entity. And so the only direct authority relationship you have is between the global governing body and the organizing committee. Now, the state makes certain promises of what it will do, which are not binding on the state, but they have to outline them in their bidding requirements. When Morocco bid for the 2024-6, anyway, the World Cup after
26.
26, yes. The king and the legislature changed a number of domestic laws because they had to say that they would address human rights challenges related to the event. Now, with regards to Qatar, the huge problem there, of course, had to do with migrant labor and how the migrant labor force was both cheated and treated. They were cheated in that the minute they arrived, their passports were taken away, their contracts were torn up, they couldn't change workplaces. If they wanted to make a complaint to a public authority, they had to make it on Friday, which of course is prayer day and all the offices are closed, and so on and so forth. Now, after FIFA, essentially in the middle of their enormous bribery scandal, they also faced pressure from their sponsors like Visa and Coca-Cola on human rights grounds. And they how should I put this?
Bluntly.
Qatar is a small enough entity for FIFA to be able to exert some influence. Let me put it that way. And in fact, FIFA did put considerable pressure on the Qatari authorities on the labor law situation, and the labor laws were changed, but the focal point of those negotiations were related specifically to the tournament. It didn't really address what was happening in terms of building hotels or infrastructure and so on. Mm-hmm. So this goes back to the sheer complexity of it. But once FIFA did what they did in terms of adopting a human rights principle, the IOC felt it needed to do the same. And they hired the former High Commissioner for Human Rights, Zaid, to develop a human rights framework, which I'm told they're using in discussions with China. So it isn't totally without meaning, but it is extremely complex, and the payoff tends to be limited.
Okay, thank you so much, John. I think I will leave it at this, so we stay in good time. And I would now invite our two panelists back, Robert and Anita. While you put your cameras on, maybe I can quickly start with maybe introducing Anita, ladies first. So Anita is a professor of law at Washington School of Law. So I appreciate very much how early in the morning she joined our round here today. Much appreciated. She is not only an expert in the fields of business and human rights, obviously she is, but also in international commercial law, sustainable development, and I think also particular in anti-corruption. That's safe to say. She has huge experience in consulting organizations, World Bank, Amnesty International, many more. I think another very interesting point for those of you who are not so familiar with her CV is that she has also worked in politics. She was part of the Obama administration and a very senior trade advisor in the US Department of Commerce, where she developed very important anti-corruption policies. And for us here, maybe most important, Anita is the vice chair of the United Nations Working Group on Business and Human Rights. Anita, maybe for 5-6 minutes now, I give the floor just directly to you.
Great. Thank you so much, Pierre, and it's just an honor to be here with John as part of this conversation today. Let me just say that, you know, the role that I serve in now, along with 4 other colleagues around the world, is that we're members of this working group. So John had the mandate as the special representative to the Secretary General, which is a very fitting title and a much better title. But when he finished his mandate, he handed over the kind of ongoing work within the Human Rights Council to this group of 5. So we are also mandate holders, and our job is really to focus on continuing implementation and engagement with stakeholders on the guiding principles. So I'm just going to a couple of comments, and then I'll really have questions for John. And I put into the chat, actually, he wrote an excellent memo, which was a sort of recommendation memo when he finished his mandate, about sort of things that he recommended that he'd like to see. So I'm going to ask him some questions about kind of, you know, as he looks now at the role of the Human Rights Council, what else would he like to see in the future? But just to say that the working group has really been, I think, another mechanism by which we continue to really push states, business, and of course work with civil society to implement the guiding principles in business and human rights. And we use thematic reports and country visits and all kinds of things to try to socialize this very important framework with states. We just launched last week, and we were very thankful to John to be part of this with a message that he's contributed, and we're going to have a session at the Human Rights Council on the 10th anniversary of the Guiding Principles, where we did a stock-taking report, and that stock-taking report looked at the past decade of the Guiding Principles and the imprint that they've had on global governance. And I think all of the working group members, and we are diverse and we have different views, do agree that this has been, the uptake of the guiding principles has been unprecedented. The way in which we have them embedded in global policy, thanks to John and his team's work, and the way in which we've seen national action plans, state adoption, right, and then now mandatory human rights due diligence. From our vantage point, is really tremendous, right? And that while we still see gaps focusing on issues like Pillar 3 and access to remedy and stronger engagement by Pillar 1, that really as an example of how a framework, and as John was saying, you know, it was good when you have this thick multi-stakeholder consensus to use this kind of a framework to move forward. I think that that's what we've seen at the end of a decade, is that success. So my questions back to John are a couple. My first one is, John, as you look at the Human Rights Council as a mechanism for continuing work on the guiding principles, what do you see as its strengths? But given a lot of the world's tensions and the sort of challenges of the Human Rights Council, what are the limits, right? So, is it an institution that is still capable of being the guardian of the guiding principles, or do we need something different? That's my first question. My second question to you relates back to your sort of crystal ball recommendations for follow-up to the mandate. You recommended a couple of things. One was you recommended sort of this capacity building through some kind of trust fund, so that we would have, I think, greater ability among all states to deal with the guiding principles. Do you think with fractured sort of technical assistance and UNDP's role and others that we've gotten there, or do we need something different? And you also wanted to have an annual stock taking. Now that has become the UN Forum on Business and Human Rights, but that's more of a conference, right? We have panels and we discuss good practice, but it's maybe not what you envisaged. So those are my three questions. The role of the UN, what do you see? The second one on kind of capacity building. And then the third would be, what do you think of, you thought of annual stock taking. How do we sort of measure government progress? Is there a better way?
John?
Well, thank you for that, Anita. I value immensely the work that the working group has been doing to keep the issue on the agenda and to expand it over the last 10 years. Your question about the Human Rights Council is a very difficult one. If my mandate had been what's the right word, established by the current Human Rights Council, I'm not quite sure what the outcome would have looked like. The divisions and polarization is so deep that I sort of, I don't even want to think about it as a hypothetical. I think my attention I know you've been working on this a great deal, is increasingly at the national level and the regional level. And we've done really well in certain parts of the world, but other parts of the world sort of remain largely where they were or only have made minor progress. And so I think focusing on where there hasn't been as much progress, and there is an entry point for the working group that didn't exist before. Both the German law and the European directive have extraterritorial implications, and so any company that wishes to operate in the internal market has to have a parallel, if not exactly the same, human rights due diligence process, and cases can be brought, complaints can be brought by people down in the value chain or supply chain, and so you have an opening of bringing cases literally to the European Union that you didn't have before. And I think that's a focus that may be worth sort of fleshing out once the European mandatory human rights due diligence is in place. As for the capacity building, first of all, I made a mistake. In that I recommended that it have a multi-stakeholder board, and in the UN context, that's I knew that, but I still thought it was a good idea to do but that was an immediate killer. And then secondly, nobody was prepared to give any money. Then you mentioned the annual stock taking. My hope was that it would lead to sort of coalition building and taking up pilot projects, for example, that people would come together around specific areas of consensus and do something as a result, not simply come to Geneva to give speeches and then go home again. But you left out one thing. At the end of the mandate, I also recommended that the human rights consider launching a treaty negotiation focused on the worst human rights abuses related to corporations. Things, issues related to crimes against humanity kind of thing. That was a non-starter, it turns out, for the advocacy groups. They felt that was already established. That's already part of international law. We don't need that. It doesn't go far enough. And therefore they said, no, we will not endorse this. Well, if Amnesty International doesn't endorse a specific treaty process, no government or no business is going to come in and say, oh yeah, we want to do it. We want to do it. So that just died right then and there.
Good. I think with that, I would introduce Robert then into our conversation. Hello, Robert. Thank you very much for joining us from Nottingham, I assume. So Robert is a professor in Nottingham, expert for human rights and international law. Mostly known probably also because he was for a very long time the director of the British Institute for International and Comparative Law, and he also has a huge experience in advising different organizations around the globe, corporations, international organizations, and so on and so on. He also has practical experience as a practicing lawyer with Brick Court Chambers, where he has already appeared before the UK Supreme Court, and I think even before the ICJ, if I'm not mistaken. So very much a litigation experience as well. So Robert, you have the floor.
Thank you very much, Pierre. It's a real pleasure and honor to be here with John, and congratulations to you, John, and your team. The UNGPs have been a transformation in terms of ideas, terminology, and focus. In fact, in my various roles, some of which Pierre mentioned, I see this impact, such as the ever-increasing number of students studying it, in the companies which are engaging with it, with different degrees of implementation, and in the amount of case law and in the legislative changes. I guess what I've seen is it's changed the platform for discussion dramatically, as I know from 30 years, believe it or not, working in this field. It's increased, of course, exponentially the number of stakeholders and their expectations, but also in the coherency in discussions at all levels and for a range of stakeholders. Indeed, the fact that we now usually call it business and human rights and not CSR is, I think, the mark of the change and awareness of the breadth of human rights issues involved. We begin to see changes in policies with investors, financial institutions warily beginning to take an interest, with credit rating agencies and others beginning to understand the S is a real part of ESG. But as we all know, there's more to do. So I just want to pick up a couple of those. In my experience, Pillar 3 is still not a reality. And even with grievance mechanisms not taken seriously by business. Anita mentioned some of the great work, including, I think, her really important work of the working group. And in its report, looking back at 10 years, it says this: UNGPs have also helped shift the focus from corporate philanthropy to accountability as an essential feature of responsible business. And I only agree in part. I think there's been a definite shift away from corporate philanthropy, which has moved to responsibility. But I don't think yet it's moved to the accountability to which you refer. Because you talk understandably about an administrative fine to a company or limits on export credit, which I think is really important, but it's not accountability to victims. And it ends up often just being seen by business as a cost of doing business, as it always was. And I think we need to move a little bit more of a step on that. And actually more public available empirical research, what businesses are actually doing, because we see this gap in the valuable benchmarks. I also think state duties, and it comes up in one of the questions, are still far from being complied with. Few states have really taken the NAPs, National Action Plans, with real teeth. A few of them are really engaging in the wording of the draft Business Human Rights Treaty. And outside the EU, very few states are really drafting legislation, and in many ways going backwards, as we see with some of the case law. And few of the international organizations, such as the development banks and the international financial institutions, are really, in my experience, taking it seriously. The other point I want to make is we need to listen to the voices. That was one of the fabulous things, John, you did. You did real consultation. But I sometimes worry whose voices we now hear. Because, for example, voices claiming to be representing business are not always the voices which are really what business are saying. And so, for example, despite the resistance of some business representatives, the very large number of businesses independently supporting the EU legislation for mandatory human rights due diligence is extraordinary and a great credit. And I think I'm going to quote you back, John, back in 2008 when you were crafting the framework, you said this: governments should not assume that they are helping business by failing to provide adequate guidance for or regulation of the human rights impact of corporate activities. On the contrary, the less governments do, the more they increase reputational and other risks to business. And that's what I'm seeing, that there's still this resistance, this hesitation in the business voice of saying, don't do it, is not always the one which needs to be heard. So, of course, there's more areas for which we can do more in this area. But I guess I'm going to ask you then one question in two parts. When you and your team devised the UNGPs, you said it was operationalizing your protect, respect, and remedy framework. You're also, I can say, very wary of having too large a role for international law in the UNGPs, even if you had some international lawyers on your team. So my question is this: do you think that the laws which we now see in legislation and cases are in some way operationalizing the UNGPs, especially with respect to Pillar 2, so that there's a different form of operationalizing?
Oh, sure, yeah.
And second question is, how do you see this legalization, if I can say it, of the UNGPs? How is it going to continue to ensure real accountability to the victims? Thanks.
Thank you, Robert.
Thanks, Robert. I agree with just about everything you've said. Pillar 3 is still underdeveloped. Well, let me tell you. Let me tell a brief story about how we came to site level grievance mechanisms. It was one of my first site visits. It was to a mining operation in Peru, which had been closed down by the community. Nobody could get in, nobody could get out. First, the police were called out. They weren't effective enough doing anything. Then paramilitary units showed up, and shots were fired. Some people were wounded and killed. The usual story that you see all too often. And then finally, after a couple of weeks, it was resolved. I spoke to the organizer of the boycott. It was a Jesuit priest. Spent an afternoon with him, and among other things, I asked him, "What led you to do this? What was it that agitated you and the community so much that you felt that you had to close down the mining operation?" And he said, "They didn't listen to us when we came to them with small problems, so we had to create a big one." And at that moment, I said, wait a minute, there has to be a role for addressing small problems before they escalate into major confrontations. And that's what the grievance mechanism in Pillar 3 were intended to do. Little did I know that the first widely advertised attempt to use this grievance mechanism was for a purpose that I never had contemplated. It was for the mass rape of women by security guards in a mining operation in another part of the world. And so I think a number of companies were sort of scared off by that example, which didn't end well for the company or for the community. And we haven't heard much about grievance mechanisms lately, although I think their initial use, I think, is still an important one. With regards to legalization as operationalization, I agree with you completely. You know, some things can be self-enforcing, but at the end of the day, to truly embed the guiding principles in systems of accountability requires national law and national enforcement.
Thank you, John. So now we're going to open up the floor to our audience. We have many people as participants here. We also have many more in the live streams that you can find on YouTube on the Institute of International Law of Peace and Armed Conflict and Völkerrechtsblog. For the audience, you can either ask your question in the chat function if you want me to read it. You can also, and I'm happy with the first question, we're going to do it like this. You can also ask the question yourself. Just indicate that you want to ask a question and we'll put the video on for you. And I think with the first person from the audience, we will do this now, which is Bruna, I think. Can we do this, JP? There you go. Can you put on your camera? Is it possible? At least unmute your microphone. Oh, there they go. Then I maybe read the question of Bruna. Should I do this? The question was higher above, excuse me. So the question we'll try again. Bruna, can you unmute yourself? No. Twice. Now, once is unmuted. Can you hear us?
Yes. Can you hear me?
Yes.
So I have two questions. The first one, and how do you see the impact of the new legislations on business and human rights to the global south, especially to Brazil, which recently backwards steps in human rights? And the second question is regarding the recent decision of US Supreme Court, which dismissed the case on child labor against Nestlé and Cargill. I wonder if you could comment this decision and what does it mean to the future of business and human rights litigation at the US?
Okay, thank you. The Brazil question is a tough one. It's sort of analogous to asking the question about the US during the Trump administration. I guess I'm no longer an official, so I can say this. The fundamental problem that you're dealing with in Brazil is your president, as was our case when Trump was president. And so, you know, we were making reasonably good progress. For example, the Global Compact Network in Brazil is one of the most active on anywhere in the world, and it still is there, and it's still bringing stakeholders together to address issues. So I think it's a matter of a particular administration, which is not going to be there forever. With regard to lawsuits in the U.S., these cases have all been brought under the Alien Tort Statute. Anita may have something to add to this, but it was a statute that nobody fully understood because it hadn't been used for so long. And when it started to be used in the case of of business, it was in a couple of cases there were settlements, but there was no outright victory for plaintiffs, and the Supreme Court had never ruled on it. And then when the Supreme Court finally ruled on it, they said, wait, there is a presumption against extraterritoriality of U.S. legislation and so on and so forth. And the recent Supreme Court decision simply used the same sort of idea that this did not touch upon the United States sufficiently closely for us to be able to rule for the plaintiffs.
Okay, thank you, Bruna, for asking your question. You can also type your questions if you don't want to go on video. I'm reading out the next question from the chat, which is from Nick Diamond. Thank you, wonderful discussion. How do you see the ongoing efforts to establish a binding treaty on multinational enterprises and transnational corporations impacting the future trajectory of accountability and the UNGPs generally? Good question.
Was that a question to me?
I assume so.
Okay, so my view on this is that the current the ongoing treaty negotiations got off to such a bad start, politically speaking, that they may be beyond rescue, even though a number of legal scholars have been trying to be very helpful and have been helpful to the Ecuadorian delegation to put together something that actually would be palatable just in terms of what a treaty is and does. But we'll see again when the next draft comes out. But as I say, it got off to such a bad start, politically speaking, that and no major home country of multinational corporations participated in the negotiations. They all boycotted it. China, Russia, Brazil, the United States, the EU. So if you were to end up with a treaty that is ratified by a very small number of countries that have no skin in the game, it wouldn't do anything. It wouldn't have any effect. It would just make things more complicated for business operations. So, but if it were possible to swing this now in a direction that was more parallel to the European mandatory due diligence laws, you might be able to get somewhere. I don't know what the thinking is on the Ecuadorian side or the South African side. They were the sort of the two main sponsors of this, but that might be, that would offer some possibility of meaningful outcome.
Good. We have another question here in the chat by Siko Lutango to John Ruggie. Where are there weak governance zones? How is enforcement of law affected in this case, since you regard legislation as operationalization? So weak governance zones.
Well, it's another tough question. We live in this sort of contradictory world where economic relations are fully integrated and operate in real time across borders, but fundamental authority is still divided among 193 states. And not all of those states have the best interests of their people at the forefront of their policies. Now, one of the things that the guiding principles stressed is that the corporate responsibility to respect human rights exists independently of what governments do or do not do. And this was actually endorsed by the International Organization of Employers as a basic principle. Is it always upheld? I think the question is no, but it is applied in many cases. But if a determined national authority is going to be ultimately in control of the situation, and if that determined national authority doesn't care about abusing human rights, there isn't really a whole lot that anybody else can do at this point in time.
I think we have now a question via video of Matvey Tarasov. JP, can you put him? Can you put Matvey on?
I'm doing my best. I'm not sure. There we go.
Hello.
Hello, thank you.
We see you from a different, from an interesting angle.
I'm sorry. Terribly sorry. I'm connecting from my iPhone. I'm waiting for a flight and had a chance to hear the wonderful presentation by Professor Ruggie, who I have mentioned extensively in my master thesis, which I have just published. And I'm grateful for the opportunity to ask a question in person. My question relates to the reform of the international investment law and the content of bilateral investment treaties, because they are increasingly including the human rights provisions often inspired by the guiding principles. But it seems to me that most of those mentions are overly declarative in their content and do not really impose any obligations upon investors. And UNCTAD now recommends that BAT content is actually changed to endorse human rights. But I personally do not see it happening yet. And I wanted to know about your insight, probably in the course of the next 10 years. Is it possible that BATs will include some obligations of the investor, which are probably arbitrable by the stakeholders, by the host states, or is it just some, vague theory and is unlikely to happen? Thank you.
No, it's a good question. I think it is a fact that there has been a transition in bilateral investment treaties away from the old style toward treaties that take into account, at least in a declarative sense, social and environmental issues to a greater extent. A serious constraint on this is still the people who do the arbitrations generally are not trained in these areas, and so their understanding of the evolving intent of the treaty writers is very poor. And if a law society could launch a project to train these folks on what this shift in the bits actually means and why it's important, I think that would make a great contribution.
Can I just add?
Robert, you're on. I'm
just going to completely agree with what John said on that front. Plus, there's sometimes a tension. If the state wants to take action against a company, let's say that they're not complying with labor rights, there is a consequence. They may end up at a bilateral investment treaty which isn't going to consider these rights. So at the moment it is very difficult, but John's point about lack of expertise is 100% correct. That was all I was going to add. Thanks, John.
I think we have a question by Dennis Dijkzeil next, also via video. Hello, Dennis. You have to unmute yourself.
Sorry. Yeah, the technical stuff takes some time. Sorry for that. But I'm really enjoying this conversation. I've got a question to ask that I would like to ask to John Ruggie. And it's more about your, let's say, organizational precursors when you started this work. Which kind of mechanisms or even people did you look at As an example, could it, for example, have been Francis Deng and his work on internal displacement with the Brookings Institute? And is there still a lot that you can learn from or that, that people like Anita and Robert and Pierre can learn from the other special representatives of the Secretary General, in particular in terms of enforcement, implementation, compliance? And there's also an other issue. I remember reading Multilateralism Matters now a long time ago. But how did your perspective on the United Nations change due to your work on this? And in particular on the relevance of the United Nations and its management. Thank you.
Thanks, Dennis, for the great question.
Wonderful questions. I think I'm going to address the second part of your question first. I think the United Nations, the role of the UN has ebbed and flowed over time, depending on essentially global geopolitical fluctuations. But there are two things that the UN has done which are insufficiently recognized, and they've been ongoing. One is, of course, the humanitarian side, the work that the humanitarian agencies play. It's indispensable. But the other, and nobody outside of a small circle of people recognizes, is that the UN has been an idea factory. There are so many extraordinary ideas that have come out of UN circles some of them are taken for granted, but without knowing where they came from. The idea of having a human development index, for example, sitting side by side with GDP. It was such a simple idea and yet such a powerful idea. There's a whole series of books published by a scholar at Tom Weiss on this, and I think I saw the opportunity of using the mandate as a platform to sort of promote a certain set of ideas. And yes, Deng did, I did look closely at Deng's mandate because it sort of, the idea of putting out principles, I think, was very much influenced by what he had done.
Pierre, may I just jump in for a second to just reflect on, and also to give John credit for what he's done post-mandate. I think one of the bigger challenges, and John, I don't know whether you would still concur, is that the institutional silos of the UN are some of the hardest to break. So where we actually have had less socialization of the guiding principles is within the UN system. Yeah. But John, one of the things that you've continued to do is really to try to draw the connection between the Sustainable Development Goals, for example, and the guiding principles, which I think is fundamental. But we need to kind of keep pushing at the UN level as well.
Let me just add to what Anita said. Everybody. ESG investing is the fastest growing form of investing in the world. It now accounts for about a third or more of all assets under management. Where did the idea of ESG come from? It came from the United Nations. It came from a collaborative project between the Global Compact and the UN Environment Program. It was the first time that it was 2005, I believe, 2004, that the term ESG had ever been used and explained. Now, nobody who talks about ESG today has any idea where that came from. So it's another example of the idea factory that no one knows about.
And another example is the working group's excellent engagement with other special rapporteurs on issues such as climate change, which is, that's in fact where ideas can spring from, that interaction.
We have a question from someone from New Zealand. Because she's up so late in the night, I want to give her preferential treatment. And she asked that I read it because probably she's in her bed and doesn't want the video now.
Oh, that's harsh on us from that part.
Carolyn Foster asks, Professor Ruggie, can you say a bit more about how climate concerns, especially emissions reduction needs, intersect with the guiding principles and developments in this field?
Well, they weren't designed for climate change, but what's interesting is that the various moves toward mandatory human rights due diligence, I think, have sort of taken the model of human rights due diligence and have said, you know, if you follow this model, and it has to be elaborated, but you can use that in terms of climate change as well. So there's a certain logic of examining your impact on things and taking that impact into account and adapting or modifying your behavior accordingly, and so on and so forth. So that there's a generic logic there that can be applied. In terms of substance, I mean, human rights and climate change obviously are intimately related because, I mean, climate change would be an extraordinary human rights disaster. I mean, if we exceed the limits of what we believe our absorptive capacity is. And poor people would suffer the most, of course.
We have a question from Irene. Maybe Jan Philip, you could put the link up for her.
It's in progress.
And our friend from New Zealand insists that she sits at the desk, by the way. I have her honor. She's
also an extremely hardworking international lawyer, I can attest.
Good. Even at 3 o'clock. There, Irene.
Hello, good morning there. So I'm very much happy and grateful for this webinar because I learned so much from Ruggie's principles. This is one of my special topic of research interest, especially in my dissertation that I'm working on about investment and as well as the interrelationship of business and human rights. So I'm interested in how these kind of Ruggie's principles become translated into the domestic sphere and what are the criteria in order to lay the groundwork for its concrete plan of action among all states, nations around the world, considering that it is a collaborative and multilateral action, as well as the transformation of transnational norms and practices on business and human rights. Thank you so much.
Thanks, Irene. John, I guess.
Yeah, I wonder if the countries that have moved toward say, for example, a mandatory due diligence, could be persuaded to establish some sort of a peer learning network about how and why they did those things, how and why they moved in this direction, rather than, you know, Anita telling them what to do or me telling them what to do. They've all gone through a political process where this was very carefully considered. You know, I have some issues with specifics of the German law, but by goodness, the fact that it exists is significant. And I know how many years the Germans spent developing this piece of legislation. And I'm sure that, well, I'm not sure, but I would hope and suspect that there would be interest by the Dutch, by the Norwegians, by the Germans, by the European Union to establish sort of a peer learning network about how and why this was done.
We have a question from Malte Spielmann, who says he can't talk himself because of a bad video. So I read it. Coming from a background of public, international, and constitutional law, can we speak of the guiding principles and recent developments in business and human rights as constitutionalization and legal reflexivity, a la Günther Teubner? So if so, how do these constitutional spheres relate to other existing semi-constitutional spheres which are primarily state-centered, such like the European Court of Human Rights or the Inter-American System?
That sounds like a semester-long course.
Yeah, I have to say he is a student of mine, so but a very smart, talented student with a lot of background. So
yeah, I think yes and no. Yes, it is in part an attempt to sort of constitutionalize the role and of globally operating companies, but you know, I've never been as taken with the idea of global constitutionalization as some people have, because it's such a weak structure still, perhaps in time, but yes, in part it is.
Can I just add one thing? What we sometimes forget is we wrap this all together and call it business and human rights. It's actually lots of areas of law, of international relations, of politics, of sociology, of business behavior. It is actually a lot of areas crammed into one. And we often nonchalantly think it's one area, but it's
right.
It draws from a lot of areas. I think will have influence in a lot of areas.
Yeah.
We have another video question. We have so many questions. We won't be able to address all. It's great. The interest seems to be really great. I think the next question is by Christina Tiliki. Can you put her on?
She's currently being added.
Hi, Christina. Good to see you.
Hello, good afternoon. Thank you very much for this super interesting event. On days like this, I love Zoom, and I have two questions. The first is for Professor Ruggie. So here in Switzerland, recently there was a vote, a vote on the use of artificial pesticides, and the community decided no, we are still going to use artificial pesticides. And it just made me think that we agree with the principles and we agree with changing the world and doing good things, but when it comes to paying as individuals, we say no, we are not ready to pay more. And my question is to you is the following. I have the feeling that now we are going after these big players. We sort of vilify them. We point our fingers at them that they are the bad guys. And I just wonder, how can we go forward and make these big players assume their responsibility, but in the same time continue endorsing individual responsibility of every single person in the world about certain issue, and still promote cooperation and collaboration between all the involved actors, which is, I think, very, very important. It will be very precious in the future. And my second question, maybe to Anita or to Robert, somebody mentioned the treaty. There is an ongoing discussion about a pandemics treaty. Of course, we discuss about this global tax agreement. Are we in another golden age of international law? And if we're not, how, because this was not the feeling that I was having last year. And if we're not, how else can we explain this boom of treaties? And thank you very much again.
Thanks, Christina.
I just want to respond to the vilifying big guys. I mean, there are some big guys that should be vilified, but on the whole, I think the big guys are the focus of attention because of the impact that they have. You know, one reason I agreed to do the FIFA project was because of the scale. When am I ever going to have that kind of scale to even make a small difference when there are more national associations in FIFA than there are countries in the United Nations. So you go after the big guys for scale. Although, you know, as I said, there are some that should be vilified, and I don't want to say anything about Switzerland in that context.
Anita?
So to your question, and I think it'll be interesting to hear Robert's response, because we do come from two different jurisdictions, right? So I, as an American, it's hard to be sort of enthusiastic about treaties as the way forward, because I don't think we'll be ratifying all of these new treaties in the US in any near time. So what can I say? Treaties in the area of transnational corporate behavior tend to have more success when there's a narrower scope, right? That what we're seeing now in Geneva with this broad-based treaty is something very different from things like transboundary hazardous waste or even corruption, right? So that's just my first point, which is that if we're going to say which treaties might have more success, it's where there's a particular harm. Corporations are part of an ecosystem where we need different actors to do different things, right? So that's one response. But the second piece is that I think, in John's work is emblematic of this, is we need to look at other ways to create these sort of consensus and action around norms. So we shouldn't underestimate the need to continue with entities like the OECD, but also the G20 and G7, because when you get commitments at a baseline, and then those commitments are monitored over time through these networks, geographically, these are interesting groups, right? Because they're reaching a lot of the different countries that we need to reach if we really do want to have action that may be more than, let's say, Western Europe and North America. So my response is just to say, we always need treaty plus whatever.
I'm not as wary of treaties for lots of reasons, but I do think we have to be careful that treaties are, of course, drafted by states, for states, and in the interest of states. And therefore, they naturally become narrower and often don't have much monitoring of the level that we would perhaps want. Even some of the examples that Anita gives, the monitoring is often quite poor. And that, of course, is because that's how they've been created. At the same stage, I don't think we should look for a massive increase in customary international law. I think that's, for good reasons, getting harder. I think it's no longer the kind of neo-colonialism that it was. And so I think treaties is one method, but I also think, much like Anita, that there are a variety of forms of drafts which may not be in treaty form, but which have an impact. An example out of this area would be the the state responsibility for international law, which is unlikely to become a treaty, but nevertheless has significant impact. So I think there are various means, but I wouldn't underestimate the power of a treaty, whether or not the US joins. I think the treaties on things such as the rights of disabled persons, I think, is really important to have. And I think the treaty on the rights of the child is desperately important, even though the US is the only state who's not a signatory. So I think that we have to be careful about determining it in political terms.
Anita pointed us to something that was posted in the chat by Professor Kassel. I don't know, can we give him the floor to make this point? Or maybe even has a question, or should I read it? I don't know. Is it possible?
I just added him as discussant.
Can you hear me now?
Yes, we can.
This is Doug Kassel. Thank you very much for a fantastic program. Thank you to John Ruggie and Robert and Anita, not only for their very helpful statements today, but for all the work they collectively have done individually and on occasion together to advance the agenda, the multifaceted agenda of business and human rights, as Robert points out. I just wanted in my comment, John, to follow up that I think there's a sleeper in this new decision by the United States Supreme Court. On the surface, it's just sort of extending Kiobel and saying, look, when we said you've got to have a US anchor for the conduct that justifies jurisdiction over human rights violations outside the United States, we really meant it. And you can't just allege that decisions were made in the US without some particulars. So on the surface, that's what it looks like. It looks like just a ho-hum continuation of Kiobel back in 2013, where they first made that the extraterritorial presumption clipped the wings of the Alien Tort Statute. But in the course of the multiple opinions that were rendered, if you count them, of the 9 justices, 5 of them expressed an opinion on the question that was brought before the court, and the court chose not to answer, probably because the answer would have been something that some members of the court would have been unhappy with. And that was, can corporations be sued and liable for damages consistent with international law? And 5 of them, contrary to the rulings of some respected US lower courts previous to this, 5 of them said, yes, companies can be sued in liability for damages. Now, because of the limitations on the territorial scope of the Alien Tort Statute, it's not going to make much difference probably for the ATS, but it could make a whole lot of difference, first of all, for any other statutes that may be passed in the future. And second of all, in other jurisdictions where business communities come together with, in this case, the Trump administration, to argue that, oh no, you can't sue companies for civil damages liability. I always thought that was a totally wacky argument when it was put forward by the US Court of Appeals in New York a decade ago. And I'm glad to see that even some of the Trump appointees on the Supreme Court of the United States agree that yes, you can sue companies provided you have a statute that authorizes you to do that, or in the case of common law countries, you could do it under the common law for violations of international law. So long talk, but thank you very much for letting the point be made, because I think this is a decision that will be widely misunderstood unless we look for that somewhat below the surface point.
You want to comment on that, John, or someone? No,
I was just going to ask Doug if he had written a short memo on this that he could circulate.
We'd all like.
It's in process, and yes, I will circulate it. Okay, great, thanks. Thank you.
We have another video question by Sufyan Drubi. I think we have really people from all over the world watching us. It's really great.
Not surprising considering the impact of the UNGP.
Sufyan, can you hear us? Do you have video as well, or do you want to ask a question? Hi. Yes.
Hi. Yes. Thank you. Thank you so much for the talk, all of you. It's always it's really very, very interesting, all this discussion. I have 2 questions to Professor Ruggie. And the first one, I'm going to be a little bit more theoretical here. On your view, what has been the impact, if there is any impact, on of the guiding principles on customary international law? At a certain point, there were great expectations that the principles will trigger some processes that would accelerate the formation of some rules. And my personal belief is that these expectations have been frustrated, but I would like to ask you about this. And the second one is something else. How has your work on the guiding principles affected your own views and approaches as an academic? For different reasons, I have two pieces in mind. What makes the world hang together, and that very nice piece on social time.
Goodness. Oh, goodness. Well, thank you for remembering those papers. The role, the contribution of the UNGPs to customary law. That's a really fascinating question, and I'd love to hear Anita and Robert address that as well. I think the vocabulary and the concepts of the guiding principles are sort of taken for granted. I don't mean in a legal sense, but in a sociological sense. I mean, the idea that corporations should respect human rights, and that respect has a specific meaning, that you acknowledge and address the adverse impacts that you you have on others, and seek to contribute to their resolution. I think that's a widespread expectation, a social expectation, a normative sort of concept, even though it isn't necessarily a legal concept, everywhere. But where I find it, what I find interesting is when and Robert has worked with a lot of companies as well. You go into any major company these days, and they have experts, subject matter experts in this field. And that wasn't the case 10 years ago. It certainly wasn't the case 15 years ago. And so it's become part of, the vocabulary, part of the way of looking at things, even if it isn't always determinative of actual decisions and outcomes. But it's there as a presence, whereas it wasn't before. So, you can say it's becoming customary, even though it may not be customary law, if you see what I mean. Second, your second question, about what impact has this had on my own scholarship. I sort of understand, obviously, I understand the plumbing a lot better than I used to. How the pipes are actually connected. But it's been a two-way street. I think the analytical work, the theoretical work that I did before, heavily informed what we did in the mandate, but then vice versa. So it's been a wonderful juxtaposition of the two. And God, I'd forgotten about that paper on social time.
I think in the interest of time, I would maybe ask our three guests for a final statement. So we are celebrating the 10 years of the UNGPs. So if I can ask you, what is your wish for, I don't know, the next 10 years, or when UNGPs come of age, let's say, when they turn 18, when John, your kids, the UNGPs, if I may say, if they turn into adults. So what is your wish for the next 8 years? Where should they go in the next 8 to 10 years? And the same question to Robert and Anita. What's the goal? What should happen?
When they get their driver's license. I think what I most want to see, obviously, is the broadening across different jurisdictions of the developments that we're seeing in the EU and increasingly in the Biden administration in the US. And the idea that it is the re-articulation of the corporation as a social entity, and not simply a piece of private property that has no social role to play. The spread of those ideas, we're at the point of escaping, I think, from the pure sort of shareholder primacy idea, and everyone is talking more about a sort of more of a stakeholder-oriented way of conducting business. The dissemination of those ideas to parts of the world where they haven't yet taken root. That and how the role of the guiding principles in doing that.
Would you like to add something, Anita or Robert? Or I'm sure you can agree with this, but maybe there's something you want to add.
I would just add 10 seconds on sort of John's point on sort of this shift of shareholder to stakeholder capitalism and rethinking this. Another piece is also thinking about the role of the corporation in the political sphere as well, that we have not yet looked, but we should, at the guiding principles and the way in which companies lobby, speak up, and finance the political system. So that's sort of, I think, another piece that will help us sort of move forward in a way that's rights respecting.
I agree. I mean, it's interesting, John's comments, because I think the notion of companies having a social purpose is coming back, even though that was obviously, Adam Smith in his day didn't dismiss that. So I would just say that thinking of the international legal system as not just being a legal system of states, and that corporations are part of it. In fact, for many, many people in the world, their major interaction with any institutional body is with a company, not with the state. The state is very far away. And I think that when we look at issues like the rule of law, we need to think of the corporate's role within it. Someone asked the question about weak governance. I mean, I think that's going to be part of how we move forward, and the sense to which this idea, which is a clever idea, just becomes embedded more generally. It's not an idea which is left just in one kind of aspect, but is seen in a whole range of different interactions, from, we've already mentioned, climate change to broader social interactions, which we often just think we leave in the hands of states who, as John's already said, are not always very representative. So I think his idea that we move it forward to have this real role and understanding of corporate activity as part of everyday activity and how we regulate it, I think is a very powerful one.
Yeah, thank you very much. Let me thank, first of all, the audience, maybe, because there was like so many people, and I know we can see on the live stream, there are many more even, and we have, I think, 15 questions that we couldn't cover. Interesting question about social media responsibility, about investment law, about different national initiatives, so about business and human rights during armed conflict. So many, many more topics we could discuss. So we'll just need to reconvene for the 11th birthday again. Thanks for the very active audience. Thanks for the European Society of International Law to support this event, in particular, Christina Binder and Clara Hernandez. Thanks to Völkerrechtsblog for live streaming this event. Thanks to Rafaela Kunz in particular. And then also for all the people in my team who have supported this. Jan Philipp, you see here, but also Lisa, Benedict, Sissy, Mareike. Many people are always behind such an event that you don't see, and they should not be forgotten. Of course, mainly the thanks goes to Robert and Anita and John. You are all very much in demand, world-leading experts on the topic, and we appreciate very much that you have taken the time to discuss these interesting topics with us, and I hope I will see you soon. And with that being said, I wish you a wonderful morning to Anita, evening to Robert, and a day to John, let's say. All the best to you, and see you soon.
Bye. Thank you.